When you see the red button,
All
I
right, the
can't
red
see the red
button.
button.
Well, the red button says meeting is now streaming live on YouTube.
Okay, so
Morning. It's the Senate Judiciary Committee. I forgot what day it is, which is common under this pandemic, but I know that it is Wednesday. And Senator Ingram has an amendment to S-219, which deals with data collection. Commissioner Sherling is here to comment on it, and Ledge Counsel Bryn Hare also to explain anything. But Senator Ingram, perhaps you'd like to explain the amendment and why you're offering it, and why you think that it should be done.
Yes, thank you. The amendment, as I said on the floor, I heartily support the bill, and I appreciate all the work that the committee has done on it, and I think it's a very good bill. I have been working on this idea of data collection and trying to improve it and introduce that as a standalone bill, S-262, earlier in the session. And I had the opportunity to work with one of the members of the racial equity panel, Stephanie Seguino, who is a UVM professor and is very well versed in statistics and data. And she actually offered the suggestions that are in the bill. I truly feel, I don't mean this to be any, opposition to what you've done at all. I truly feel that this would be a way to strengthen the bill and improve on what's already good. But since some of this work has already been done, I thought that I would offer it for your consideration. So just briefly, the proposal is to amend only Section 3. So it would be to substitute this language for what is now Section 3 in your bill. And it adds some different categories to the kinds of data that would be collected. For instance, it adds the passenger, not just the driver, but the passenger. If there's any contraband that's found in the car. This is all about traffic stops. And then a few different categories about force and injury, possible injury, or the impairment of the person to begin with, the year of the vehicle in the state, the duration of the stop, and the total years of the officer's service. And then the next part of it is it adds the executive director of racial equity as a person that would be a part of collecting receiving the data, as you had done in S-219. But it changes from the private company that is the vendor now that was chosen by the Criminal Justice Training Council, which I believe you've heard some complaints about that company as well. But Stephanie Seguino was quite adamant that she really felt that they were not doing an adequate job. So it shifts that to the Office of the Attorney General, the thinking being that, they are a public institution, they are a public entity and would be accountable to the people in a way that a private company is not. So that's essentially, what's contained in the amendments. And I appreciate your considering it. And, as I said, I just had already done this work on it and felt that it would be worth taking a look at it.
Thank you. Any questions for Senator Ingram?
Senator
Baruth.
Quick question. The one that jumps out at me as the biggest change is moving it from the private vendor to the AG's office. Has there been any discussion with the AG's office about whether they're willing and able?
I had spoken to David Scher quite a while ago. I will confess, since COVID and everything, I haven't talked to him since then. But he's the one that's in charge of racial matters, and he was supportive at the time. It's been a while.
Okay.
I'm not sure that this is are questions. I have some comments and some real concerns about it, but I'll wait if that is more appropriate for discussion, because they're not necessarily, I guess the question for Senator Ingram is, what is the purpose in collecting some of these things, like the duration of the stop? For example, if you have a stop that lasts, my sheriff sent me his last months of stops, and he had a stop that lasted 46 minutes. The reason it lasted 46 minutes was because it was a DUI and they were waiting for the tow truck to come and get the car. And he had one that was 20 minutes because the guy couldn't find his insurance card and spent 20 minutes looking under seats and everywhere for his insurance card. So I don't understand why duration and years of service in the force would be. And so I have some other real concerns, but around the invasion of privacy of passengers. If I'm a passenger in a car, they have no right to ask me what my age or gender or race is. I don't believe. And also whether the cop thinks I have a psychological impairment, and that's public information, remember? So now the cop writes down on there, she seemed a little scattered. I think maybe she's depressed or bipolar. They're not equipped to do that. And that now becomes public information, and everybody in Putney sees that I have a disorder. So those are my concerns. They're not particularly questions, but I guess my just question would be, what is the purpose? How is this used to help set our policy?
Yeah, in general, the purpose, I mean, those are, very good questions. But the purpose is to identify ways in which people of color might be treated differently from white people, basically. I mean, for instance, the duration of the stop, the examples you gave are perfectly legitimate reasons why the stop might take longer, but there have been, instances in which, say a Black man is detained much longer at a traffic stop than is necessary, than a white person, say their brake light was out or something, and they could just be, it could, sort of border on harassment that they kept the person of color, longer. So those are the kinds of things, the state that the person was in, would help to identify whether, it has to do a lot with what we feel the officer is judging, and if there is any basis for perhaps discrimination because of the way the officer is interpreting things. So, generally.
Can I just add here on this login sheet that he sent me? It says call type, ticket, date, time, on scene at, cleared at. So that's already collected. I don't understand.
It's not uniformly collected, is what my understanding is from Stephanie. She was telling me that when they receive information, it's not necessarily consistently collected, and it's not reported consistently. So it's very difficult.
Which is something we are working on.
Okay.
Senator Benning has a question or comment.
So Deb, first off, thanks for bringing this. It's opening up a conversation that I think we need to be considering as we go through this process. And we've heard from several people, slow down and make sure you do this right. 37 years as a criminal defense attorney had me looking at the data collection portion of this with a very skeptical eye. The pretext for a stop in many instances is relatively minor. And I'll use the example of a recent case that I had where the pretext for the stop was your license plate is covered with snow, I can't read it, which blossomed into a heck of a lot larger charge, felony drug situation. And this is not an uncommon event. I'm not going to say it's common, but it is certainly surfaced enough in my work that I'm concerned when you expand the necessary data, you are expanding the length of time of interaction between a person who is stopped and the police officer. And bad things tend to happen the longer that goes on. There was a car in Hardwick that had 4 individuals in it that had pulled over. So it was about 1 o'clock in the morning. It had pulled over so 2 of the people could get out and relieve themselves. And an officer came, and what should have been a simple, "Hi, what are you guys doing here? Are you okay? All right, be careful. Thank you, goodbye," turned into a full-scale shakedown of all the individuals involved. And that led to subsequent charges, drug charges for all of them, because the officer decided along through that process that they probably wouldn't mind if a dog came along and sniffed the car. Those kinds of things happen to people of all skin color. And when we are talking about adding the necessary material that an officer has to collect, you are actually increasing the length of time that the officer has to question people. And that in turn leads to invasions of privacy like Jeanette is talking about, because this material is all on a public dispatch log. And I'm going to have to push back a little bit on whoever told you that data about the time of the stop and the end of the stop is not collected uniformly. Virtually everybody in my neck of the woods that I'm aware of sends to the state police dispatch where they are, what time they made a stop,
Yep.
when they concluded that stop. So I think that information is already available. But giving the officer a reason to ask questions about race, that material comes into play along with the officer making observations about mental health or asking questions about mental health. And this amendment would in fact give them state authorization to continue the conversation in a way that could have the opposite effect of what you're trying to accomplish. So I'm somewhat concerned that it hasn't been fully fleshed out yet. It's a conversation that we need to have in a much wider setting. And right now, I'm just not comfortable without witnesses from both sides coming in and talking about this subject. So if I vote against your amendment, you know why.
Mr. Chair,
Yes, Senator Baruth.
question for Bryn. I don't have our 219 in front of me. So I'm looking at the amendment only. Doesn't 219, as we passed it yesterday to third reading, doesn't it expand the categories of collection for the kinds of contact? So in other words, some of what's here in terms of use of force is already covered in what we passed in 219.
Some of it is, yes, that's correct. So for the record, Bryn Hare from Legislative Council. What Section 3 of 219 does is it expands the data collection to use of force, whether physical force was employed in effectuating the stop. So that there is an overlap there. So the type of force is not, there's no requirement in S219 that the type of force that's used. I'm sorry, there is a requirement that whether force was used and the type of force be collected. But other, like the type of resistance offered is not required in 219.
219 reads, whether physical force was employed or threatened in effecting the stop, and if so, the type of force employed, and whether the force resulted in bodily injury or death, and whether a written warning was issued, blah, blah, blah. And so it's somewhat similar to Senator Ingram's amendment. Although I don't see it getting into the justification of the stop in that sense. Senator White.
So could I ask just another clarification here? My understand about the vendor. My understanding is that the way it works is that you have
maybe Commissioner Sterling would be a better person to ask that.
Well, I want to pose the question first so that he can see if
Okay.
did you have all these agencies that collect the information, and what we're trying to do is make sure that they're collecting them in the same manner, so they're using the same coding. Then that information gets fed into the vendor, who then collates it in a way that can be sent to VCIC and other places, and that the vendor, that is the role of the vendor, is to collate that information as it comes in. And if I'm wrong, I mean, if I'm right, why would that live with the AG's office? This is I thought a technical thing that the vendor did, not a response to public or anything. So just correct me if I'm wrong on that. Thank you.
Who?
Somebody.
Michael Sterling, Commissioner Sterling, are you available?
I am,
Commissioner.
sir. Sorry about the
Oh, no,
glare.
sun
It's
looks
fine.
good. We don't see any sun here in southern Vermont today, right now.
I don't think it's sun. I think it's just daylight. To be responsive to Senator White, that is correct. We have two vendors right now. I do want to take 1 second and just say the folks that are being referred to as the vendor is not a for-profit entity. Every state has selected one of these folks to do data analysis, and they are a trusted entity. They do data analysis not just on our race data collection and traffic stops, but on opiates, on domestic violence, on sexual violence, on overall crime. And it gives me great pause when I hear folks saying that there has been testimony here at the legislative level with distrust of what these folks do. They do it in good faith. They do not do it. They do not do data analysis with any outcomes in mind, and they use trusted methodologies that are in play on a national level. So I really want to push back in the most stern terms around any distrust around the external data analysis that's being conducted at a statewide level. With that said, there are challenges to the two platforms that we use to collect data and how they allow data analysis to be done. And Senator White is exactly right. That's where the challenges have historically been. We are on the precipice now of a selection of a statewide system that would enable not only better data collection in the field, but much more robust data analysis at the back end, to include the development of public-facing dashboards that would show the public, municipalities, and others data on the fly without having to be a data scientist, and at the same time provide raw data to anyone who's interested in analyzing that data, whether it's one of our colleges or universities, an external researcher somewhere else in the country, or someone who just has an interest in data and wants to unpack it on their home computer. All of the information that we're going to be collecting in the future, the next level of transparency is to allow others to analyze that data and query it and ask questions of it that in some cases we haven't even thought to ask, and then loop back to us and say, hey, did you know that your data says X? And we may say, no, we didn't even think to ask that question. So that's the future of data collection and analysis at a macro level.
Thank you,
I have other comments on the draft, but I will hold for the chair to.
If I could just say, Commissioner Sterling, I don't think I used the phrase distrust of the company. What I have heard is that what you're talking about the platforms and the lack of the dashboard has been of concern to a lot of people. I said that the Office of the Attorney General would be a public entity, which I think would be an added bonus. I didn't say it's because we don't trust what the vendor is trying to do. I just don't think, I think it could be strengthened, the data reporting, if we had a different way of doing it.
I appreciate that, Senator. I would just suggest that it doesn't need to be recodified in law at this stage, because we're going to make all of this data as transparent as possible. And if we fail to do that, then I would suggest that the codification be that we simply are mandated to put all of our data, not just around race data collection, on force, on responses within communities, on all the things I've mentioned, domestic and sexual violence, of course, redacting personal identifying information, but all of that data should be forward facing for anyone to query in any way that they're capable here in the 21st century.
Thank you. I have a couple of suggestions. One would be that we take up S-264 in August. S-264 is the amendment that's being offered by Senator Ingram.
262. Yeah. I believe.
No, actually, my computer said, you may be correct.
Anyway, okay.
Whatever.
Whatever
We
the
take
number
up S-264 or 262 in August. There is another issue that I wanted to raise about, we did hear many witnesses during our discussions of this suggesting that we should not just be limiting to traffic stops, but also stops of pedestrians, stops of other nature that are made. So because if you know, rural communities, it is traffic stops, but in some of the cities and major towns, they are also pedestrian stops where somebody is stopped and so forth. So I think it does deserve more discussion. I will mention that there have been disagreements. There was a study done a while back by the University of Vermont that involved the Bennington Police Department. Then the Center for Justice Research did a further study of that, and the two groups disagreed strongly on the results of both. And so you had the argument between whether you call them vendors or people that were assessing the data ended up in a big argument. So I do think that issue also needs to be resolved. However, so Senator White, who's an expert on.
No, I was just going to say, could we hear, the commissioner said that he had some other comments, and I would like to hear from that, because my intention, unless I'm convinced otherwise by somebody, is to vote against this amendment. But I would like to hear the commissioner on the other aspects.
I'm suggesting that we continue the conversation about this subject that's been raised today yesterday by Senator Ingram's amendment, that we continue that discussion after the July break in August, that there are other things regarding data collection that need to be examined, including the vendor, but we could use S-264 or 262, whichever the number is, as a vehicle for that discussion. So if you have questions, if Commissioner or Senator Ingram, did you want to comment, and then Commissioner Sterling?
Thank you, Mr. Chair. I would be satisfied with that, and I would withdraw the amendment so that the committee can take more time. And I appreciate your willingness to do that. And I would respectfully ask that you do definitely take it up in August rather than wait till 2021, just because I won't be in the Senate in 2021. So I would love to be able to kind of see this process play out. So I appreciate the committee's attention to it, and if you will give it a good thought later, I would withdraw it.
Assuming that Judiciary is able to meet after the August break, after the July break in August, we will take it up. I believe that that's the intent, to have committees meet and work on legislation during the break, as well as the big bill. So that would be the only thing. And I recognize that who knows who would be the chair of Senate Judiciary in 2021. So I'm not counting any eggs, and maybe a bad year for incumbents. Bryn will be the chair. I don't
just a guess.
Okay, well, she may be. Commissioner Sterling, did you have some final comments?
I think I have a variety, but I think I hold most of them, other than a couple, just as folks are thinking about this over the next couple of months and maybe adding to drafts. Collecting data on all interactions is the goal, as Senator Sears indicated, not just on traffic stops, that we should be able to unpack this for all community interactions. I agree with the comments that both Senator Benning and Senator White indicated about some of the concerns about scope and the potential for creeping into other sort of fishing expeditions on stops with some of the data that's being collected. But most importantly for future drafting, the section on collecting information, biographical information on passengers is currently not legal in most instances. We have to have a reason, I have to have reasonable grounds to identify and interact with a passenger. We can't just do that blanketly. So you'd be creating a statutory construct that would create a whole set of interactions that would be new. And as Senator Benning indicated, all kinds of things can happen when you create more complexity roadside, both the things that he indicated, but there's also a variety of other concerns I think we would have about expanding time roadside.
Thank you, Commissioner. I had the bill on my computer here, so let me check the number. You are correct, Senator Ingram. It is S-262, which was introduced by Senator Ingram and Baruth, others. Senator Baruth, as far as the committee goes, it is 262. So there is a commitment to take up the issues contained in S-262 after the July break, and we look forward to continuing the conversation. Unfortunately, Bryn had to leave before we could finish because she has to watch the house. I don't know why anybody would want to do that, but
Maybe
I think she has a choice.
I guess it's her job. I don't know.
I guess, yeah, that would be the only reason.
Right. Well, thank you all very much.
Thank you very much, Senators. I appreciate your
Thank you,
Thank you.
Senator Ingram.
Thank you.
Have a good day. We'll see you at noon. All right, committee. The next, and thank you, Commissioner Shirley. And you're welcome to stay around for deeds.
Who would?
I have plenty to do, Senator. Thank you for having me on short notice.
No, you're welcome. Thank you. All right, Eric.
Yeah,
Welcome back.
thank you.
I don't know how far you've gone in the last, since we saw you last. Have you made it out of the city?
No, not yet, I'm afraid.
Right.
Still close to home like everybody else.
Eric, I would like to take up, if we have time this morning, H 963, if you can be prepared for that, the Act on Sunsets.
Yeah,
So,
sure.
I'm not sure how, I don't plan to vote out and enhance life estate deeds until we get back. Because of timing and all, and it hasn't been put on the list, but we do want to take it up. So if you could kind of walk us through the bill, it's H 837.
Yes, that's right, exactly.
What's 936 that you just mentioned?
That's the sunsets bill. What happened was the House in our miscellaneous judiciary bill got uncomfortable with their ability to pass it by July, by
Oh,
week. So they pulled out all the sunsets were in the miscellaneous judiciary bill and put them into their own committee bill on sunsets, which Eric drafted. But evidently they, instead of eliminating the sunsets as we did, they extended the sunsets.
I see. So tell me the number of that new bill now that we're looking at.
Well,
I think it's 963, I think.
963. It's an act relating to sunsets related to judiciary procedures.
Right.
I'll post it on the website too, so you'll be
Yeah,
ready.
please. Yes, please. Thank you. So, Eric,
Yeah. Should we start it on H 837 first?
please.
Okay. Morning, everybody. It's Eric Fitzpatrick with the Office of Legislative Counsel. Good to see you all again this morning. It's here to talk today about H 837, which passed the House. It's an act relating to enhanced life estate deeds. I don't know if anyone has had a chance to look at it yet, but I think one of the first things that would jump out at a person looking at it, even to Senator Benning and myself as attorneys, is that there's a lot of highly technical legal language in there. And it becomes apparent immediately when you take a look at it. So it's one of those bills where it's helpful for me to just talk for a minute or two and describe what's going on before sort of getting lost in the language right away. I think it's kind of will help with the language ultimately, and might even go fairly quickly once we kind of understand the concepts here. So life estate deeds, then to sort of get right into the background, is essentially a probate and estate planning tool. So what that means is, if you think about it, and we've dealt with those sorts of things in the Senate Judiciary Committee many times over the years, it's basically a decision about what a person's going to do with their property when they die, right? That's your estate planning. Whatever property a person may own, you make decisions about how it's going to be dispersed, who's going to take that property when you pass away. That's an estate planning decision. We've talked about that in here actually just this session when we were talking about the bill regarding remote witnessing of wills. And remember that we discussed the whole probate process in that context. And that's one way that you can distribute property when you die. You can draw up a will. And in that will, you specify who's going to get what, who's going to get which property, which person it's going to go to. And then in that case, the will goes to the probate division. It has to get processed and proved by the court. And the court will designate an administrator, or there could be an executor named. And that person would be responsible for distributing the assets that you had. That's one way you can distribute assets when you die. You could use a trust, for example. You could put property in trust and the trustee would oversee it, and it could then go to the beneficiary when the person dies. You could even say nothing. Many people don't have wills. And if you say nothing about what happens to your property, then Vermont statute takes over. And again, the probate division would oversee it, and the property would be divided up according to the order in which people take property when a person dies under Vermont law. So a life estate deed can be looked at exactly that same way. It's just another way to distribute property when a person dies. And it applies specifically, this is an important point, to real estate only, what's known as real property. So it's a way for a person to decide how they want their real property, very frequently their primary residence, but doesn't have to be, but that is probably the most common way that it happens. A way to have your primary residence pass along to the person that you want it to pass along to when you die. That's been a tool, a probate tool, estate planning tool for decades and decades, and longer than that. Actually, I remember in law school studying life estates. Senator Benning probably does as well. And I was doing a little reading about it. Well, hopefully, right? It's one of those things. I think it was even, there was a question on the bar, if I remember correctly, that was dealing with.
Why I went into criminal law, Eric.
Yeah, wise. Yeah, wise decision.
We have several attorneys who will be witnesses, Joe, who may disagree with you.
More power to them.
Right, right. Well, it's interesting because I was reading back on this concept of a life estate goes back as far as feudalism. You know, it's sort of, and it's the concept itself has been around for a long time, but it's developed through the common law for centuries. Essentially, it's been in practice, been used in Vermont for a long time. So the question then is, so what is it exactly? How is it different than an ordinary deed? Well, when you think about when you deed property from one person to another, ordinarily, you know, a house, you have a deed, and the seller was known as the grantor, or it could be a donation, doesn't have to be a sale, but the person who's transferring the property is the grantor, and the grantee is the person receiving the property. And you execute a deed, and the grantor signs a deed, the grantee signs a deed. They decide that the property could transfer right then immediately. It could be a few days down the road, but it happens right away. The transfer happens right then. A life estate deed is different. The transfer does not happen right away. The way it works is that the grantor, the person who's granting an interest in the property to the grantee, reserves all the rights of ownership of the property. They still own the property. They can mortgage it, they can transfer it, they can gift it to somebody else, and most importantly, they can live in it. So the person who's granting it gets to live in it or do anything else that comes along with owning the property for as long as they're alive. So that's the key. It's not forever. That's why it's called a life estate. The person owns their property, their interest in the property, for as long as they live. And at the end of that time, when the person dies, that's when the grantee automatically acquires the property. So at the time of the transfer, the grantor retains a life estate. So as long as they're alive, they get to live in it, they can transfer it, do whatever they want. And the grantee gets what's known as a future interest. They don't get a present interest in the property. They don't have any rights right now, but they have a future interest. And that future interest is actually a specific type. It's called a future contingent interest. And the reason that it's called a contingent interest is because their ownership of the property is contingent upon the occurrence of some future event. See, it's contingent. They don't, it depends. Sort of a brief little question here, I suppose, to make sure we're all on the same page so far. What contingent event is that grantee's interest dependent upon? What contingent event has to happen in the future for them to own it?
Death.
The die.
Yes, exactly.
Well, I have
Yes.
a question though, Eric.
Yes,
There might be another contingency. I
yes,
had a relative who had left his property to his daughters, 2 daughters. He, before he passed away, his house burned down, completely destroyed. So there's basically nothing left. What happens then?
right.
I mean, obviously he didn't do that, but you know, the house did burn down, and so now they own nothing, right? I mean, does
Right.
that end it, or do they just own the property that it was on?
Well, I suppose it would depend upon how the deed was drawn up, but generally, if there was no property left whatsoever, then there would be nothing left for the
Well,
grantee
you
to
said it
get.
was just on real estate, so that's why I'm asking.
Yeah. Well, if they had originally done the life estate to include the house and the land and all that, I think that, and I think the practitioners will be able to answer this question more specifically, but I would think that the grantee would get a life estate in whatever was left. You know, maybe if it was just the land, then that's what they would get.
And a cellar hole.
Right. Yeah. And, you know, maybe there was insurance that helped them rebuild.
Yeah,
I don't know.
I don't remember all the details. This is years ago, but I just, as you were talking about it and talking about they can do anything they want, but
Right.
you know, natural disasters do strike.
Yeah, exactly. That's true.
It's the same for personal property, Dick. If the jug behind you, you put in a will to say your grandchild or whatever, and your will has not yet been executed because you haven't died yet, but that jug is lost in a fire. The fact that your will still contains that language doesn't mean your grandchild gets something different. They don't get whatever you had
They don't get
originally planned to
what
get.
no longer exists. Okay,
Right.
that's helpful. Alice, you had a question?
Just wondering, before you go further, can you rescind this deed prior
Yes.
to the death? Okay,
Yeah, and we'll get to that right in the language, but that absolutely revocation is that's something that the grantor can do anytime.
and can I just clarify, you said it's based on your residence, but can it be based on your land if that's what you put into a life estate? Land
Yes,
without
yeah.
a residence.
Yep. I was only saying that it tends to be most commonly a residence, but it could be any property.
Okay.
Any land, any real property, not personal property, not,
Yeah.
your car, your boat, your money, that sort of thing, not that, but any
Could be
real
a forest,
estate.
forest land or something like that.
Sure. Yep.
All right. Do you
Your-
want to,
your-
would it be better to hear from the practitioners now and then wait?
Well, let me just
till-
do a couple of quick more minutes to give you a little bit more. 'Cause
Okay.
We're just about there, which is that I think, that's the concept of a life estate deed, is that the person essentially deeds to themselves a life estate. So while they're alive, they have all the incidents of property ownership. They live there, they can transfer it, whatever, and they deed to this other person this future interest, this contingent interest that doesn't occur until the person granting it dies. And when the person dies, the grantee automatically becomes the owner of the property. So the obvious question that might come up is, well, you could certainly do that same thing with a will, right? You could drop a will and do the same thing and say, all right, I want my house to go to person A or person B or whoever. So why use a life estate deed instead of a will or some other method? And that's important features to know about this. And there's two main reasons. The first one is because the grantee automatically becomes the owner of the property when the grantor dies, it doesn't have to go through probate. There's no it's an automatic transfer of ownership. So as people know with the probate process, it can take a lot of time, it can cost a lot of money, it can be, whether it's attorney's fees, court fees, and that doesn't happen overnight. So there's a cost effectiveness and a timeliness benefit for using this mechanism sometimes, often for people of modest means. So that's one reason that they're frequently used.
Can I just ask, Eric, I get that. And then I'm thinking that when my mom died, for instance, she had made me co-owner of her property so that when she died, we avoided probate because it automatically became mine. But the life interest is this sweet spot where you avoid probate, but you also avoid having the other person be a co-owner during your life where they have current property rights. So it's a way to avoid probate and to avoid co-ownership during life.
Yes, that's exactly right. And one of the consequences of that is that if you're a co-owner, often called a joint tenant, you could be your creditors could go after the property. Just to be totally honest, just for full disclosure, I have a life estate with my mother right now. She lives in the house. And one of the things she asked me before we created is, well, hopefully it wasn't going to happen, but she goes, well, what if you end up bankrupt? Can your creditors come after me? And I said, no, because with a life estate, the creditors of the grantee cannot go after the property because remember, they don't own anything yet. They have no interest, not until the person dies. Whereas, as you were mentioning, Senator Bruce, if you're a joint owner, you do own something right then in the present.
Yeah.
So that's one of the benefits of using this tool. Another main one to mention quickly has to do with Medicaid planning. And it's similar in the sense because the grantee doesn't own anything yet, but for what's known as the Medicaid clawback, you folks probably know more about it than I do, but I've become familiar with it during the course of this bill. If while the grantor, the person who owned the property is alive, if they incur medical costs and Medicaid pays for them, Medicaid has the ability through what's known as the clawback to go to the probate court if an estate is being probated and say that person who passed away still owes medical bills, and they can get the money back from the probate estate in the probate court to pay for the person's medical expenses. Use of a life estate avoids that clawback, so that again the person doesn't own anything yet, and the Vermont Department of Health Access has recognized this for many years, that this is an exception to the Medicaid clawback, and they're aware of it, and they know about this bill that was discussed in the House. So doesn't change anything because, as I mentioned, this tool has been used for a long time. We're just putting in statute, codifying a practice that already exists. So, but that is another advantage.
Senator White.
So is this similar to, or is it a different when my mom first moved to Vermont, she had a small savings. I mean, not some retirement funds. And she was approached by a couple attorneys who said, you should set this up as a trust so that if you have to, so that you can leave this to your children instead of having it used for Medicaid nursing home expenses. And she actually was so offended, she told him in very uncertain and not very ladylike terms to get lost, because what it was saying essentially was that she wanted to be able to leave it to me and have everybody else in Vermont pay for her nursing home if she had to use that. Is this similar to that?
Well, I think it's a conceptually similar in the sense that the use of this particular tool can avoid the Medicaid expense issue in the same way that a trust kit. I think the difference is that the life estate is much less complicated and much easier to do, and therefore usually it's for people of modest means. So that if you think about it, I think Medicaid only kicks in as a provision of last resort. You have to spend everything down that you have, very, very close to zero before you can qualify for Medicaid. 2,000, right? So only people of modest means anyway. In other words, if you're a very wealthy person, that's probably not going to happen to you. You're not going to spend all your money down and be on and be able to qualify for Medicaid. It's only
so you put it in this trust. You put it in this trust thing, and then you have nothing.
Well, but
so
then
Medicaid covers.
They can look.
I resent that.
They can look back over 5 years too. By the way,
I know.
so I don't want to get into a
Okay.
discussion of Medicaid law. I would just say that based upon personal experience, if you live long enough, unless you're extremely rich, you will run out of money. Joe?
I will never run out of money. My wife is 4 years younger than me. Eric, first, let me thank you. I wish you were my wills and estates professor back in law school. That was a very nice explanation.
Thank you.
Having the bad feeling that I'm going to be the one reporting this bill, I'm looking for a very easy way to explain this, and correct me if I'm wrong. Under current circumstances in a life estate transaction, the grantor is not able to transfer the property when there's a life estate executed. But under this enhanced life estate deed, they would have the ability to transfer. Is that?
That's correct.
Simple way of looking at it?
Yes.
Well, I'll let the attorneys chime in on that when you hear from your witnesses. But the way I understood it was that it's not so much that you can't transfer under current law, it's that the consequences of attempting to transfer are unclear. And part of the reason for putting this in statute, for what has been a practice for a long, long time, is that there are inconsistent decisions from the trial courts, inconsistent understandings by the title insurance companies, by the banks, for purposes of insuring these transactions as to what the consequences are of things like what you just mentioned, Senator Benning, if either an attempt to convey it or as Senator Nick mentioned earlier, what if you change your mind? What if you decide, well, I don't want to do that? Then there's lack of clarity about, well, what does that mean? Does that mean that it automatically essentially destroys the entire life estate that had been created, or what does the owner take at that point? So there's this ambiguity that has, again, I think the witnesses will talk about this more, that has resulted in some difficulty getting insurance sometimes.
Okay.
Thank you.
The deed that is incorporated in the language of the bill, is that now going to be universal for all life estates? Or are life estate transactions as they currently exist still able to be made?
It's the latter. So that Now there is a model, the bill does contain a model form deed. So that, it could use the model form, but there's also language in the bill that says, first of all, any pre-existing life estate still is fine. And if you read the way the very first section of the bill reads, the application of the chapter, essentially what it says is any transaction in which the grantor reserves a life estate and the grantee gets this contingent future interest when the grantor dies, that's going to be governed by this chapter. So in other words, it doesn't specifically say you have to use this deed, but if it does that conceptually, which we just discussed as to how that works, then the rules of this chapter about what happens when you try to convey it, what happens when you try and revoke, can you more, that sort of thing. It's to try and unify that practice.
Okay.
I have one final question for you, Eric, and then we'll get on to the witnesses.
Sure.
I noticed that all the language is underlined. So I'm assuming that this doesn't replace current law. It creates what has been common law and true court decisions, replaces that. Is that?
Yes.
That's exactly right. It takes what has been common law and codifies it in statute for the purpose of common understanding, making consistent the rules and the practice.
Well, then I would say our next witness is Joseph Barr, attorney, Franklin Grand Isle Bar Association, who has actually commented on a couple of the questions. So, Joe, welcome to Senate Judiciary remotely.
Thank you. Can you hear me?
We can hear you. We cannot see you. But that's.
I don't know what I need to do to make it.
Click the stop video button at the bottom left.
At the
Or if you're,
oh, there it is. I got it. All right. There.
Oh, nice to see you.
Good morning. Yeah.
Good morning.
Senators. Yes, I'm an attorney and I'm a member of the Franklin Grand Isle Bar Association, which has been working on this for a few years. I would correct one thing that Eric said. There is two levels of of life estate deeds. One is the standard life estate deed, which says I convey a piece of property to somebody and reserve a standard life estate which terminates upon death. In that instance, the person that I convey it to does get legal title. The difference between that life estate, the common life estate deed, and this enhanced life estate, was now being called an enhanced life estate deed. Past has been known as a Grand I deed or Italian deed or Lady Bird Johnson deed or whatever you want to call them, is that grantor reserves all of the rights to convey or reconvey or rescind the property, and the grantee receives no rights at all in the property until the grantor dies, and the grantor and the grantee's creditors have no rights to the property until the grantor dies, and the grantor can do whatever they want for the property while they're still alive. Eric is correct that this type of deed has been recognized by the Vermont courts since 1950, and have had a variety of decisions over the years which have addressed some of the interests of parties that in the deed, in these type of deeds. However, it is that uncertainty. There is an uncertainty as to what some of those rights are, and because of that uncertainty, there are difficulties in some transactions of obtaining title insurance. In some instances you can't, currently in Vermont, and in cases of mortgages, currently most lenders will require that if you're going to get a mortgage or refinance your property during your lifetime and have one of these deeds, they require you to basically rescind the transaction, which in this instance also they require that all the grantees sign off and start over again. Sometimes that's a problem. I had a case where a well-meaning person gave the property on a enhanced life estate deed to his 4 children. Decided at some point in time, much later, that he needed to make a change, mainly because one of the children had become addicted to opioids and had entered into a long and rather unfortunate criminal lifestyle. And he wanted, instead of that person getting her 1/4 share, she wanted ultimately for her daughters to get her share if upon his death. We ultimately got that, but it took 2 years in the process of tracking the individual through the criminal justice system and jails and etc. But and sometimes that doesn't happen. Sometimes somebody says no, and because of that, because of what happens when somebody says no. And then we have Andy Michael at Vermont Attorney's Title saying, yeah, okay, now we have a problem and we need to resolve it. The other issue that's problematic is that the banks want to make sure that they can get it, that they have a clear title to the property, and that the life estate deed and the interest of the grantees is subordinate to their interests. And that become an issue over the years, and this bill makes it clear that the mortgage, these deeds and the conveyance themselves are subject to the existing mortgage and to any refinance mortgage, and that there's no need to re-execute a new deed in the event of a granting of a mortgage. Briefly on the issue of Medicaid, if you will, this Medicaid does, there is a specific rule that recognizes life estate, enhanced life estate deeds as being a non-disqualifying transfer. That, as I said in the memo, which I sent to the committee earlier, there is a limit on that. If the value of the property is over $585,000, you're going to have to do some buy down of that value in order to use a enhanced life estate deed to transfer that property. That's a primary residence, and the Medicaid applies to Medicaid planning. The Medicaid planning exemption applies only primary residences. It doesn't apply to non-primary residents. You can use this deed to transfer real property that's not the primary residence, but that would still be subject to Medicaid. And the Medicaid exception for primary resident enhanced life estate deeds for primary residences is just for primary residences. But those are that's in a nutshell of is why what this is, why we need the legislation. It has become apparent that that people are using this across the state, and it's clear that without this legislation, the issues, the concerns about what would happen, what are the nature of the grantee's rights, what happens if one grantee dies, what happens if when the grantor rescinds or attempts to rescind or revoke, and one of the grantees says that they don't want to. And there is a case in Ray Weed in which the grantor did attempt to revoke and rescind and reconvey the property without all of the grantees signing off. And our Vermont Supreme Court said that in that instance that the grantor had not reserved all of the necessary rights to do that, and that the grantee and since the grantee refused to sign off, that conveyance was void, and that gave rise to changes in the form of the deeds that the attorneys throughout the state used, but it didn't eliminate or remove the potential questions that we had that give rise to the title issues that I discussed. I'm happy to answer any questions you have.
These newfangled machines, often talking while muted. Thank you very much, Mr. Bauer. Are there any other questions for Attorney Bauer? Thank you so much. We appreciate your clarity.
You're welcome.
Andy, Michael, would you like to comment on life estate deeds?
Yes, good morning. Hopefully everybody can see and hear me.
We can.
Hi, Andy. For full disclosure, I should point out that Andy and I were in the same class in law school.
Yeah, I thought you were going to say that,
Yeah,
he was the one that taught you everything you know about probate, Joe.
Yeah, thanks for that, Andy.
yeah. Well, you may have run from real estate law as I ran from criminal law. I think I tried maybe 2 cases, and that was enough for me. Thank you very much.
Yeah.
So just for the record, Andy Michael, I work for Connecticut Attorneys Title Insurance Corporation. That is Vermont's only domesticated title insurance company. Caddick also has a reinsurance company that is located here in Vermont. I run the Vermont branch. My office is known as Vermont Attorneys Title, but if you hear Vermont and Caddick all in the same, that's basically me here in Vermont. I have just a few brief comments about what is probably the least sexy bill that you guys have talked about this session. Before I do that, though, just if I could take a minute and speak as a Vermonter, just wanted to thank the committee and in fact, the legislative body for the incredible work that you guys have done since March. None of us on this side of the camera have any real idea. We read newspapers, we watch TV, but the pressures and the decisions that you guys are making and the change that you've implemented in, say 90 days is amazing. So thank you for all that you do for Vermonters. And,
thank you so much.
Yeah,
appreciate that, Andy.
Absolutely. You guys are amazing. We can talk about mechanics, but I'll keep my comments at the 10,000 foot level. This does not create anything new. These are being done on a daily basis. They've been done for decades. What we're really trying to do is create some uniformity and predictability. It is a very important estate planning tool, as we've talked about. This statute exists in other forms in several other states. Joe may know all of them, but California, Texas, and there are a few other states. So we're not inventing any wheel here. Just a quick example of how it does, by codifying this, it does create uniformity and certainty is say section 658. Right now, a traditional enhanced life estate deed is mom and dad giving their family home to, let's say, 3 children, son, daughter, and stepson, whatever. Normal course of events, mom and dad die, the 3 children inherit or receive the property through the deed. That's great. What is happening now is we have more and more of these deeds in the chains of title is one of the children predeceases mom and dad. Mom and dad either forget that they have an enhanced life estate deed or don't have time to change it. So then they die. Now there are 2 living children and a deceased child. Who gets the interest of the deceased child? Right now, we don't really have a statutory answer, and the common law never really thought about it. So people often run off to court, or it creates uncertainty. 658 sets forth a couple of different scenarios, just as what if a grantee predeceases a grantor. It just tells you what you need to do. So predictability, uniformity, certainty, etc. As Joe and Eric mentioned, I think there have been several Supreme Court disputes over these types of deeds. And I think if this statute had been enacted when those deeds were drafted, and more importantly, if the practitioner had utilized this uniform deed that we have in the bill, those cases would have stayed out of the courts. The statute creates definitions, the deed creates certainty again. So it is non-sexy, but it is important. And thank you so much for taking the bill up. You know, I know you guys are about to adjourn, and I know you got a lot of COVID stuff going on. So thank you.
On some case, I guess in some respects, the COVID pandemic has led people to look at their estates and how they should deal with them. So I think it actually is timely to that particular part of this pandemic. But it also, your remark is really helpful to understand that there have been several cases that have been confused by our lack of this law that other states have.
Absolutely.
And I don't, you know, I think we all, I've actually, there was a woman in Franklin County who was constantly attending Senate Judiciary Committee hearings because of the loss of her family home to her brother, I think it was, and was constantly feeling cheated by the side judges of Franklin County. And it was a sad case, and she often brought her dispute to the Senate Judiciary Committee, which obviously was not able to resolve it.
Right. And I guess I might just add that we've heard no opposition. This has been spread out through the Bar Association, the real estate, the probate, judges have weighed in. Yes, we've fine-tuned a few things over on the House side, but to my knowledge, there is no person, group, et cetera, that is opposed to passing this.
Since you mentioned forms, we've often had disagreements here whether the legislation should have forms in them or not. And Eric has, over the years, drafted some bills with forms and some without. That's a specific reason, if you might comment on that, if the question came to Joe on the floor, if Joe reports the bill?
Yeah, exactly. So there are as many drafting techniques as there are real estate attorneys out there. And as an attorney, I think I can say this, everybody thinks they can build a better mousetrap than the last deed that they're reading. So what happens is, you know, maybe even more importantly, a non-real estate attorney might pick up one of these deeds and not necessarily knowing what they're doing, try to copy something that isn't right. They've either added extra language or omitted language. So by having the reference in the deed that it is a statutory deed, there are defined terms, there are terms used in the deed that are then defined in statute. So we know exactly what the intent of the parties was when they drafted that deed, because it is written in statute. Right now, there's a litany of words. You can do X, Y, Z, A, B, C, but if you leave out double A as a reserved power, the grantor doesn't have it. So the purpose of the statute is to create the definitions, define what's happening, incorporate them into the deed, and to make deeds simple and easy, as opposed to being 20 pages long with, you know, a bunch of flowery words. You can use one or two words and you're done.
Thank you. Other questions for Mr. Michael? Joe, and then
Andy, your last comment, that will, however, require a statutory change should a decision be made somewhere down the line that this boilerplate has to be changed.
If I
Am I
could,
right?
I'm sorry, I didn't.
question was from Mr. Michael, Joe, and then we could hear your comment as well afterwards.
Sorry, Senator, I'm not sure I picked up the nuance of your question.
Okay, the statute will incorporate a boilerplate deed.
Yes.
If for whatever reason need comes along the way in the future to change that language, you will then have to have a change in the statute to match that. Am I wrong?
I think you are correct. If that were to happen, hopefully we've created our definitions broad enough. My sense would be the form of the deed is fine. What might be tinkered with would be the statutory definitions, would be my, quick thought.
Joe, did you have a difference of opinion?
Yes, this is, I want to make clear, this is an optional form. It's not required, Senator Benning. In other words, you could use, this is a fail-safe form. So, if
it would be, Joe.
What?
It would be, Joe, except that if down the road somewhere, the decision is made to change the language of the way an LED deed, I think that's what you're calling it, is created, this remains as an option on the statutory books. So I'm envisioning that if in fact somewhere down the road changes are made, that change is also going to have to be made in the legislature as a result of this being a statutory option. Otherwise, you could create a conflict between whatever is now needed and what the statute offers as an option.
I agree with Andy. I could see some changes in the definitions, but the form of basically the form, the optional deed simply refers to the statute. In other words, there's not language. The language in the language of the reserved rights is it just says it reserves the rights provided for in the statute, and it's certain in Title 27, Section Chapter 6, which is the heading, and
I guess
and,
we're
and
going
a
to
common
have
law and a common law right, a common law life estate. So I don't see it would be. I understand your question, but I suppose some factual matter situation which would result in that, but it would be a change. Right now, all it does is refer to the statutory provisions. It does not contain a recitation of rights, other than to refer to the rights reserved provided in the statute itself. So if the statute changed, if there was a statutory change of the definitions or the rights, even at some point in time in the future, the existing optional form deed would simply refer to whatever those changes were, because it simply refers to the rights reserved in the statute. It doesn't recite them.
Is it clear that this is an optional form?
Yes, it says
Yeah.
optional at the top.
Optional, yeah, in the heading 660 optional form.
Yeah.
All right. Anything else from either Andy? Robert Pratt, our final witness, if you'd like to comment.
I would. Apparently, I have no camera.
Well,
You're going to have to enjoy the mellifluous tones only.
well, Robert,
Or you
since you're a
could click
frequent
on your
visitor
video.
to judicial rules, we can live with that. We can,
Okay.
we'll do our best.
This bill started out with some significant opposition to some details. I have been persuaded that the title insurance obstacles merit that this pass, although I am not persuaded that the title insurance obstacles are legitimate. But they're there and I can't control the title company. So the deed offered as optional is really a safe harbor. I would be reluctant to call it a fail-safe. But it's supposed to be a safe harbor that if you use that, you're going to be okay. And as Joe Benning points out, Senator Benning points out, something could happen in the future to make it not so safe or maybe not even work. But I'm down to one major objection. By major, I mean vigorously objected to. And I'm going to take you back a little bit to some of the terminology with some wish that Eric had done a little more reading. A life estate deed is not by its terms revocable or changeable. It's locked in. And go back to Senator Sears' comment about the 5-year rule. We do those for any kind of real estate. We want to start the 5 years and get through the 5 years, because then we've locked in the protection. But we only use the enhanced life estate deed by necessity for primary residence. We can use it for anything, but we only do it for primary residence because of Medicaid. Instead of a contingent remainder, which the statute uses and which we all practitioners use because it helps our clients understand to a certain extent what's going on, what is really being given is a defeasible remainder. So I take exception to the comments which have been made that when we give this enhanced life estate deed, the grantee gets nothing. It's a remainder interest. Well, it's a real remainder interest. They get something at the time of the transfer, but it's defeasible. It can be taken away. And depending on, without this standardization, depending on the quality of the draftsmanship, what can be taken away and why and how is covered by the language of the deed. One of the Supreme Court cases said, you reserve the power of sale, Mr. Lawyer, and you didn't reserve a power to make a gift. And so you can't make a gift. You can only sell, and you must sell for a reasonable price. And so that transaction was declared void because it tried to do something that was not within the reserved rights. Bad lawyer drafting. So the piece in this legislation to which I object is 655B. A grantee of this contingent remainder, which for me is a defeasible remainder, cannot convey it. I can give you a lot of examples of why grantees might want to convey their remainder to a spouse, to children, to business associates, all sorts of reasons, family reasons, marital reasons, tax reasons, business reasons, why they want to get this remainder out of their lives, rather than going back to the grantor and saying, please redo the deed and put in my place somebody else. There's no reason that I've been informed of except this notion that the remainder, that the grantee doesn't get anything. There's no reason why this remainderman shouldn't be able to convey his remainder, because he can't convey more than he gets. And he gets a defeasible remainder. He gets something that can be taken away. And when he conveys it to somebody else, it can be taken away from the somebody else. He can't give more than he gets. And because I can think of lots of reasons why remaindermen would want to do that, I object to this statute saying it's not permitted.
Mr. Chair?
So is your solution, just if I could, is your solution to strike B?
Yes, it is.
Okay. Senator Farouk.
I have a question, I guess, for Eric, but maybe for the practitioners as well. Is this provision designed to ensure the overriding desire of the grantor? In other words, I grant my son this future interest, and this makes sure that he can't then subgrant it to someone else that I don't agree with. Is that why this is here?
Andy, go ahead.
Well, first, I apologize to the committee. I wasn't aware of this objection, so my representation a minute ago was absolutely wrong, and I sincerely apologize. I don't recall this coming up on the House side. But anyway, the reason it's in there is to create the certainty that we talked about. Right now, between the conveyancing bar and perhaps the probate bar, there are at least 3 or 4 different theories about what this interest conveys. What do the grantees get? Nobody knows the answer. So as these happen, we can all run to court and we can call it a tomato or a grape or an apple. It doesn't matter. So by creating certainty, and my opinion, at least from the real estate conveyancing bar, is that 80+% of the conveyancing bar, if they were here to testify, would say, we believe they get a contingent remainder interest. That's basically how this came about. To Senator Baruth's question, yes, from a title standpoint, if parents grant to the children, one of the provisions is that well, either as a matter of policy, we don't want the children to convey it out, but the more practical issue is those children may well think they were deeded the property. If they don't understand the nuance that they haven't acquired anything yet until their parents die, and assuming their parents haven't conveyed it, it's only then that they get it. So I've run into a scenario, and there's legal malpractice to be sure, but the children went out under one of these deeds, acquired a $400,000 mortgage, and the grantor changed his mind and deeded it to a third party. The bank is now sitting there with a $400,000 mortgage signed by somebody who didn't have an interest in the property, and we're off to the races and off to the court. So I don't know that it's super duper duper important what we call this interest, but why we put this in here is the overwhelming majority of people consider it to be this, and creating certainty is important.
Senator?
Mr. Bauer, and then we'll hear
Yeah,
from
I
Robert
would
Pratt
echo
again.
Andy's comments and also point out that Bill makes it clear that the grantee reserve at this point in time of the original conveyance receives no interest whatsoever in the property. We want to make sure, underline that by including this subparagraph B to 655. It would destroy this whole mechanism or procedure if a grantee could convey his or her interest to a creditor, or Judge Brown in the bankruptcy court decided that the trustee in bankruptcy of one of the grantees could require a conveyance to their creditors, and or just on a more personal basis, the parents grant this to three of their children, and one of the grantees conveys it to someone outside of the family, and that the parents have no relationship to and don't want to have the property go to. That's why this is in here. And to provide that certainty, that's I think it's essential in order for us to go forward and have the certainty of what this interest is. The grantee received.
Thank you. Mr. Pratt, do you want to comment on either of those comments?
Yes, to Senator Baruth's comment, the enhanced deed allows the grantor, if one of these transfers occurs, to redo the deed and to eliminate the introduced stranger. Maybe it's a family member, maybe it's a stranger. The objection to that might be, well, what if it's done in secret and he never knows about it? So I grant you that. But the notion, which has been stated here, that the grantee gets nothing, suggests to me that therefore the deed does nothing. And if the deed does nothing, then what is the point? In fact, we can call it contingent remainder or defeasible remainder, but in fact, there is the conveyance of a remainder interest. A remainder interest that can be taken back. So the grantee does have something. And one of the purposes of good drafting, and one of the purposes of this standardized fail-safe deed or in my case, safe harbor deed, is to make things uniform so that the title insurance companies will insure title and the banks can work with this, although for underwriting reasons, many of them won't anyway. But I disagree strongly that the grantee gets nothing. What they get is something that they can lose. And I'm just opposed to this limitation on retransfer.
Appreciate that. It appears that the committee will have to make a decision one way or the other on this particular section, whether to include it or not include it.
Senator Sear?
Yes, sir.
Yeah, I want to just make it clear, we're saying that the grantee receives no present interest in the property during the grantor's lifetime. They do obviously receive a contingent interest. And this only limits the grantee's right to convey during the grantor's lifetime. It's not, they can do whatever they want to with their interest after the grantor dies. So this limitation in B is it shall not convey the grantee's contingent remainder interest during the grantor's lifetime. So if they do it, they can do whatever they want after the grantor dies.
Eric, any thoughts?
No, thank you, Senator Sears. I mean, I think the witnesses have articulated the different points of view on it pretty clearly. I don't have much to add. Thank you, though.
Peggy, if we would schedule this for 11 o'clock tomorrow for markup and possible vote,
Will do.
if that's convenient for you, Eric.
I was going to say, are you available, Eric?
Yep, that's fine with me. Thank you.
All right. Thank you all witnesses on this bill. We appreciate it. And Robert, sorry we couldn't see you in person, but your voice was there, and we have met you a number of occasions, particularly in judicial rules, and we appreciate your perspective.
Well, I think we're all better for my absence.
Thank you very much. We're going to turn to H963, Eric, if you could.
Thank you very much.
Thank you.
Thank you.
See you later, Andy.
Where would I find that, Peggy? It's on.
I posted it on the website for today. You might have to refresh your screen.
Oh, I did. Okay, I got it. Thank you.
You're welcome.
So they did sunset extensions of the same sunsets that I don't know why they did what they did. I never know why they do what they do. But they are the house. So.
Yes, I think for at least for the first two sections of H963, that's right, Senator Sears, because those two sections were both in S234, the miscellaneous bill. Exact same issues. The sunset involving the court diversion programs. You probably remember that. That's the prosecutor's ability to,
right,
or requirement that they state on the record for certain types of referrals and that sort of thing. And then the second one is the racial disparities in criminal juvenile justice system. Advisory panel, both of those are slated to sunset. I guess it's next week now, right? July 1st.
Yeah.
Hard to believe. So yeah, in S234, the Senate had repealed those sunsets completely so that the changes to the diversion program would become permanent, and the racial disparities advisory panel would become permanent as well. I think, paraphrasing what the House did on this, and it was actually a decision that was made more at a meeting I happened to be at the House Rules Committee as opposed to House Judiciary, although House Judiciary obviously followed the decision that was made in House Rules, which was they didn't want to, while the pandemic was going on, repeal any sunsets. They wanted to extend them for a year when they would have more time to come back and think about them. So I think it was a broad decision, not just about the sunsets that are in this bill, or that were, sorry, that were in S234. They made this broad decision and then pretty much applied it to any other bill that came along. So that's where it came from. And
That's helpful. I don't
yeah.
know that I really feel strongly, particularly about given the work involved in the racial disparities in the criminal and juvenile justice system advisory panel to give it only one more year is troubling. And the court diversion I don't feel as strongly about. I mean, but it means we're going to come back and look at these in a year. And I think this is ridiculous. Further what they've done, I'm not happy about this whole thing. And the license plate readers, that's till 2022.
Yeah, that's another one that's supposed to sunset next week on July 1st, 2020. And that they extended for 2 years because that was DMV's recommendation. That's pretty much the reason for that.
Well, I'm sure if you asked the the RDAP panel, they would have recommended a longer life for themselves too.
Well, we can do that. It means it has to go back to the House to concur with us. We can vote this out exactly the way it's written by the House, concur with the House, move forward, and take it up again next year, or we can go back to our language, which I prefer. And I'm fine with agreeing on the license plate readers. That's not as big a deal. I find it, particularly the racial disparities council. I'm not comfortable with that, but it's a committee choice. If it goes back, it could die until August, and then you've got these things sunsetted.
Yeah.
Senator White and Baruth.
So I think that just repealing the sunset for a year and then coming back, I would hate to see it go back there and linger around and die, and then they actually are sunsetted. And I think that we should just say it's going to be sunsetted for a year. I have no doubt whatsoever that I can't even say the word, it's RDAP or something like that, board will continue.
Yes, Senator Baruth.
I'll just second what Jeanette said. I think at this point, given where we are, sending it back and extending the sunsets makes sense, as they've indicated, even though I disagree with the rationale and what they came up with, but in effect, everything gets extended. My quick question for Eric, I'm assuming that if there's a delay on the House side, and there is technically a sunset of, say, the RDAP panel, that this language would retroactively reinstate it? Because
interesting question.
Because I think it's likely that the governor doesn't sign it before it sunsets.
Correct. I'll double check with Michael Grady on this. I know he's looked at the issue, but I think I agree with you. I think that that's the right result because although it technically has sunsetted, let's just say, I don't know, for 5 days or a week before either the governor gets a chance to sign it, or even if it got pushed back to August, whatever way that it happened, there was this gap. Because the language of the amendment actually goes back and changes the original bill from 2 years ago, then yes, it would revive this. It would revive the whatever the underlying statute is. It's not as much of an issue here, at least not with respect to. I'm probably using the wrong acronym too, but RDCJ. It's not as much of an issue with that because whether the panel exists or doesn't exist for a week or two or a couple of months, not as big a deal. That can become a tricky situation with other more practical things, like say the diversion one, where for a month, say, or a few days, a given law wasn't in effect, right? Because the repeal had happened for even for 5 days. What if there's some case in the system that's involved, a referral to diversion or something that would have been covered by the statute? Then it gets a little more murky because someone, technically the law that applies to a given case is the law that's in effect at that time. But the courts have dealt with those kind of things before, so I just sort of throwing that out there as sort of a wrinkle. But generally, yeah, I agree with the point that even if it doesn't done till later, it does act to revive the statute that had been repealed for a short period of time.
Well, personally, I guess we have little choice but to go along with the House's move. However, I will on the floor, I plan to report this bill, and I will on the floor state my objection to the process. S-234 should have been dealt with by the House during this time. They knew it was there. They fiddled with it, and then they stripped out all the sunsets, put them into this bill, sent them back to us. Then they also took out of the miscellaneous bill the provisions that are particularly acute to the Bennington and Windham County state's attorneys and domestic violence programs. So those grants were taken out by the House, which means that it's created more problem than it's worth, in my view. They didn't have to do it this way. So if there's a problem, there's a problem. And I would like to vote on it this morning, and we'll vote it out. I'll report it. Eric, since there's no change, I don't know what I have to do with Bloomer. But if we can get something to him right away, would be helpful.
Yes, and I have a summary I can send you as well if you want to use that for reporting.
If you would, please, yes. And I will try to get it taken off the notice calendar tomorrow so we can send it out tomorrow and go through all the stages. I don't think I'll send an email to Senator Ash.
So I would, if you do go ahead and vote, Senator Sears, I will send the document, which is the as passed version, to Senator Bloomer and CCU, and just say that Senate Judiciary just voted this out.
Yep.
And Senator Sears, you'll just have to respond to confirm the vote.
Yep. Okay. Great. Thank you, Peggy. Is there a motion to report favorably SH 963 as passed, or whatever, H 963?
I make the motion.
Senator Nitka has moved that we report favorably S 963. Any further discussion? Hearing none. Peggy, could you please call the roll?
Sure. Senator White,
Yes.
Senator Baruth,
Yes.
Senator Benning,
Yes.
Senator Nika,
Yes.
Senator Sears.
Yes, and I'll report this, and we can now change our agenda for tomorrow morning to take up H bill at 9:30 instead of 11.
Let me ask you this. Right now we have H 688 at 10 o'clock, and I know the commissioner can't be there till 10:30. So do you want to just start it?
Commissioner of what?
You had asked me to get, hold on, who was it?
Peter Welk?
Yes, he can't make it. Julie Moore is going to come and she can't be there till 10:30.
That's fine. Julie Moore's
So-
fine.
So you want to do that at 10 o'clock and 11 o'clock?
Yeah, but no, at 9:30, we'll do H 837, the estate deeds. Hopefully vote on that.
Okay,
And then at 10
9:30.
o'clock, we'll take up 688.
Okay,
And we've got Luke scheduled, then Robert McDougall, and then Laura Murphy,
and Julie Moore.
and then Julie Moore, and that's plenty.
Okay, great.
The issue on it says the climate solutions thing, bill, and it has judiciary section, and I thought it would be better if we looked at it. It creates a right of action. And so that's what we'll be looking at. We don't have possession of the bill. So, but I think, I'm sure on the floor, somebody will say, well, Judiciary should have looked at this. At least we can say we did or didn't. Okay. So with that, I guess we can adjourn and then rush to our next Zoomer. Eric,
Just to confirm the time for tomorrow. So we'll do H 837, the estates bill at 9:30.
if you're available.
Yeah, that works for me.
Good.
I just, since we had said 11 earlier, Peggy, you might want to let those witnesses know that it's going to be 9:30 instead of 11.
Yep.
Yeah,
will
good
do.
idea, Eric. Thank you.
Yep.
Sure.
All right. See you all. See some of you at noontime. See the rest of you tomorrow morning.
Yes.
Yep.
See you tomorrow.
9:30 tomorrow morning, not 9:30.
Sounds
We're
good.
on at, are we on at 9 right now? I mean, 11:45 right now?
We're on the
Yes.
floor at noon.
Okay,
We're on the floor at noon.
okay. I
And
gotta
then-
run upstairs.